Judge Fleischer is well known for being firm, fair, and absolutely done with nonsense.
I'm not working on hunches here, man. He was doing what that was wrong?
Known for calling out shady behavior in his courtroom, things hit a whole new level when a clearly innocent man ends up in cuffs, and Judge Fleischer, he's not letting it slide.
Saying, hey, this guy did this over there. The cops go, no.
And that's the basis of arrest?
Kicking things off, we have a case that had Judge Fleischer genuinely puzzled by the officer's actions. Let's just say their reason for this arrest didn't actually exist. It raised more questions than answers.
Good morning, Mr. McLean. Sir, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, yeah. An officer initiated a traffic stop in Harris County, Texas, after observing the defendant exceed a speed limit of 45 miles per hour and make unsafe lane changes. The defendant did not have his driver's license, but told the officer his name and date of birth. While the officer was running the defendant's name, he observed the defendant exit his vehicle, and the officer told the defendant to get back inside the vehicle. And the defendant responded, "Do I have to?" The officer exited the vehicle and attempted to detain the defendant. The defendant tensed up and locked his arms.
Everything is conclusory. And what has he done wrong?
You're right.
What?
With the initial lane changes, unsafe lane changes, and the exceeding the speed limit that prompted the stop. And then at that point, he was just...
Stop. How exceeding speed limit? How fast was he going? I mean...
I spoke to the officer this morning. He told me that he was pacing the defendant at 54 miles per hour.
Okay, in a what?
I'm sorry?
In a what? I mean, if it's on 610, he's fine, right? And then he's interference duties. What is he interfering with? What did he do wrong?
I think it was after the stop was initiated, the officer was running the plates. The defendant stepped out of his vehicle. The officer told him to get back in the vehicle. The defendant said, "Do I have to?" The officer told me that...
And that's the basis of arrest?
See how it was split your eyes.
Don't. Are you losing?
Oh, sir.
Okay.
And Your Honor, furthermore, as he was attempting to detain him, he locked his arms and tensed up. So as he was attempting to detain him, following that incident of him telling him to get back in the vehicle. And it was
That's the basis for arrest.
It was just a temporary detention. He was just attempting to detain him while he was trying to
What's he
investigate.
doing wrong?
He
What's he doing wrong?
65. Yeah, 65.
No, I don't think so. You can find no probable cause. No, it's just, he gets out of the car and then it just the virtue of fact him getting out in the car, it's interfering with the duties. Really? No. Just, when you get into, just be careful out there, man.
Yes,
Life is hard as it is.
Yes, sir.
When you get into, gotta be careful, man.
Yes, sir.
People always have to get you. Be nice. It's not hard. Things will go well for you. Look, I got it. I'm with you, okay? Just hang tight with me for a second, okay? All right.
And just like that, the case was dismissed. Why? Because the judge couldn't find a shred of probable cause. Turns out there was no actual reason to arrest the defendant.
What's he doing wrong? He's like trying to get away from him. He's like doing the right thing.
Imagine getting tossed in jail for doing absolutely nothing. That's exactly what happened here. Yeah, the defendant committed no crime, yet the cops still slapped on the cuffs like it was a hobby. You're going to want to stick around to see the judge's face when he realizes this arrest had zero justification.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. Officers were dispatched to a Holiday Inn in Harris County, Texas, in response to a disturbance. The caller reported that two white males left the property, one in an F-150 and one in a Mitsubishi. When the officer arrived, he observed a Mitsubishi, which matched the description given in the parking lot, headed toward the nearby road. The officer initiated a traffic stop and made contact with the driver, the defendant. Officer asked the defendant if he was involved in a physical disturbance, and the defendant stated yes, that him and another individual got into a physical fight and that he got into his car to separate himself and calm down. The defendant stated he was headed toward a gas station when he was stopped by the officer. While speaking to the defendant, the officer observed an odor of alcoholic beverage, glossy eyes, and slurred speech. The defendant admitted to drinking 2 beers, and standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 0 out of 8 on the walk and turn, a 0 out of 4 on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were a .103 and a .113.
Judge, I'm going to say no probable cause here because
What's he doing wrong? He's like trying to get away from him. He's like doing the right thing. You know?
and probable cause doesn't exist. He's 0 for 6 on the walk and turn, 0 and 6 on the one-leg stand. There is no law in Texas that a person cannot drink. Just because he smelled alcohol does not mean the person is intoxicated.
Do we have anything that he's doing, you know? Tell me what led them to him.
Yes, sir. So what led to the investigation was a caller who reported the disturbance. The officer arrived and he observed a car which matched the description that the caller
That would be
gave.
like me calling and saying, hey, this guy did this over there. The cops go, no. I mean, theoretically, would be anyone could make a phone call, make an allegation, cops go, boom, and just stop, do whatever they want without, no probable cause.
Thank you, Judge.
Be careful, man. There's a lot of haters out there. Don't let them get you, you know? Life's too short. All right? All right, good luck.
The prosecutor barely had to lift a finger. Judge Fleischer took one look at the case and shut it down immediately. There was no probable cause, no logic, and no clue why the defendant was even arrested.
On earth are you going to know that you're parking more than 18 inches? What time of day or night was this?
Up next, Judge Fleischer is handed a case so absurd, even he looks like he's questioning the police officials. You can practically feel his frustration through the gavel. The reason for arrest? Completely ridiculous.
Mr. Hardy, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. Shh. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 22nd, 2024, the officer observed the defendant's vehicle parked more than 18 inches from a curb on a public roadway in the right lane of a two-way road in Harris County, Texas. While the officer ran the motor vehicle, the passenger side door opened, a black female exited, and the female approached the patrol vehicle. The officer made contact with the female and observed a strong odor of marijuana emanating from the female. The officer made contact with the defendant, the driver of the vehicle, and observed a strong odor of marijuana and had the defendant exit the motor vehicle. A PC search was conducted and the officer located 3.5 in the driver's side door and 1 blue package with Oops All Berry on the front containing green leafy substance on the rear driver's side floorboard, 1 red package with Fruity Pebbles on the front containing a green leafy substance in the back seat, and 2 clear plastic baggies containing green leafy substance under the front right passenger seat. The officer also observed 1 burnt marijuana cigar behind the front passenger seat and 1 small chunk of loose green leafy substance in between the driver's seat and the door. The green leafy substance was identified as marijuana based on training experience, and the weight was 54 grams or 1.9 ounces.
He was doing what that was wrong?
So he was parked more than 18 inches from the curb on the right lane of a two-way road. So he was out.
On earth are you going to know that you're parking more than 18 inches? What time of day or night was this?
Your Honor.
Is it parking while black now?
As the judge hears the arguments, his face says it all. This case is straight up nonsense. Every claim gets more ridiculous than the last, and Judge Fleischer's reactions? Priceless. It's the kind of courtroom chaos that makes you wonder how this even made it past paperwork.
Your Honor, there's no time listed. It just says the officer was on patrol around the 3518 block of Arbor Glen Drive when he observed the vehicle parked more than 18 inches from the curb.
And so he goes up to the car because of that?
No, Your Honor, a female passenger side exited the passenger side and approached their vehicle, and he observed a marijuana from
But because he comes up to them. Right? Stop. Are you losing?
The officer wrote as he ran the vehicle, presumably the license plate.
Right, he pulls him over.
They were already parked on the side of the road 18 inches from the curb, and he came, I guess, parked behind, and he was running the vehicle, and then the passenger side door opened, a black female exited and approached his vehicle, the patrol vehicle, and he observed an odor of marijuana on the female, and then he made contact with the driver, where he observed marijuana odor in the vehicle. So the female approached the patrol vehicle.
Show me in the penal code that code. What is the penal code for that?
Regarding the 18 inches from the curb, sir, is that the
Yeah.
issue of what we're talking about?
Yeah, because they come to him because he comes to them. Right, they're just parked. He comes to them. It's got to be a transportation code, not penal code, you know?
And Your Honor, regarding the timeline of events, it does appear that when they were parked that distance away, which could be arguably further, I don't know what it looked like at that time, but the female passenger is the one who exited first, and that was before officers ever made contact with them. So I don't know if you were thinking that the officers approached them first, but I just wanted to clarify that she approached first.
What time of day or night was this?
Trying to see that, Your Honor, in a second.
You can delineate at 4 a.m. that parking 18 inches from a curb.
And I found the regulation, the statute in the transportation code where it says you have to park within 18 inches.
At 4 a.m, you can tell.
Your Honor, the officer was,
Yes, I don't think so. All right, I'm going to find no probable cause.
yes,
All
Judge.
Guys, be careful, right?
And just like that, another bogus arrest, tossed out by a judge who actually knows the law. No bias, no nonsense, just the simple truth of no probable cause.
No one sees him driving.
He was just parked across the street.
No, no.
Judge Fleischer's no stranger to wild cases, but this next one might have you questioning if judges are the only ones doing their jobs around here.
Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 2nd, 2024, officers were dispatched to a minor accident on Sam Houston Parkway. Upon arrival, the officer met with both parties of the accident as well as a witness. The witness advised that there were minor disturbances on scene in which a knife was brandished by the defendant who was parked across the street from the accident. The officer identified the defendant and discovered he had a mandatory suspension on his driver's license for a second DWI. And the defendant advised that he had still been driving for work. He had personal business despite having personal knowledge of the suspension. The defendant stated he was driving from San Antonio and was only waiting for his coworker who was involved in the accident.
Does he have an open DWI right now?
Does not appear so, Your Honor. It appears that the last DWI he had was in 2019 out of Bexar County. Bear County, yes, Your Honor.
Okay. Mr. Patlan,
Yes, sir.
I want you to understand one thing. I'm going to find that there's... So, wait a second. Someone saw him driving, or did the officer see him driving? Because I didn't...
He admitted that he had been driving for work. And he admitted to having personal knowledge of suspension as well.
Did anyone see him driving?
No, Your Honor, there's only the
Do we
state.
know even when he was driving?
There was an accident. That's what dispatch involved. And then
Okay, so, okay, so,
there was an accident, and then officers arrived, and then they made contact with the defendant.
got it. So all this was in response to an accident that he was allegedly involved in.
Yes.
Got it. All right. So I am going to find probable cause, Mr. Patlan. And no, don't. You have the right to remain silent, exercise. I've got about a bunch of DAs here. Anything you say, they're going to use it against you. But let me make something abundantly clear to you. I'm going to have you sign with me today an affidavit. This is a promise that you're making to me that you're not going to drive. I don't care what is going on in your life. When we mean no driving, we mean no driving. I don't care if there's a burning building and you have to save 50 kids. Do not drive. If you do, I can have a contempt hearing facing up to 6 months in jail and a $500 fine every time you drive. Do you understand? I don't care what your excuse is. You cannot justify at all any reason. If you want to drive, go get a license, get liability insurance, and then we can talk. But until that point, I will even do this. This is the number to the DPS driver's license division. If you call them, they can tell you exactly what you need to do to get your license back.
Classes now, sir.
There may be, an SR22. You may have to do all these other things. What you need to do is call them and they can advise you, but don't don't drive.
And just when you think it won't get any crazier, this case gets hit with the wildest plot twist. You won't believe what comes next.
Correction, after reading the full DIMS, the defendant was parked across from the accident. It was his coworker that was involved in the accident. He was parked across, Your Honor. And I do apologize. After reading the complete DIMS, the officer wrote that the defendant was parked across the street from the accident, and he made a statement that he was waiting on his coworker who was in the accident.
No one sees him driving.
He was just parked across the street.
No, no. What? Really?
He made the statement that he was.
I get it.
He was in the vehicle and he made the statement.
I took a shower today. No. I mean, you just make a statement. I mean, no, there's no proof.
To having knowledge of the suspension, and he was in the vehicle parked across the street.
But no one sees him driving?
He did make a statement.
No.
The only crime this man committed was standing across the street from the accident. Yup, that's it. The judge was left completely stunned on this baseless arrest.
Officer, I don't understand why they wouldn't do just a little bit deeper dive.
Well, when they're on the field and it's...
The saga of wrongful arrests just keeps going. This time, Mr. Martinez ends up behind bars, not for something he did, but because he shares a common name with someone actually wanted by the police. And Judge Fleischer, sadly, he is no stranger to this kind of mix-up.
That's it.
Morning, Mr. Martinez. You have a very common name, and there are a gajillion Francisco Martinezes out there. There's an unfortunately, there is someone wanted in that jurisdiction that has your name. And you see now that you've been wrongly arrested, you're going to be released today. The fear is that this continues to happen. So I don't know. There are methods out there. And Mr. Kim, you say there's a letter that he can get.
Yes.
What we're going to do is, I cannot give you legal advice, but I'm going to have your lawyer that we've appointed to represent you tell you how you can take care of this so that it doesn't happen again. So we're going to process you out. You should be out within hopefully the next 4 to 6 hours. Ricardo will tell you how to go about getting a letter so that this doesn't happen again. Do you have any questions? Did you want to add anything, Ricardo?
It's fair to say, Judge, it's just a bad situation. This man was arrested for this, not even,
Yeah.
it's not a good situation.
Yeah, I mean, mistakes have been made, and I don't know, I guess the arresting officer, I don't understand why they wouldn't do just a little bit deeper dive.
Well, when they're on the field and it's obviously an arrest in the evening, is us being one of the few agencies that's truly 24/7, is that they can only confirm by teletype for whatever the fugitive division is. And so with it's most commonly name and date of birth, and statistically that should narrow it down, but it's just,
I mean,
because you can't take photos, or you can't send
have mobile apices?
for that when they get processed in, but that only brings them in for, again, the same name and date of birth, but you can't trade mugshots with the demanding jurisdiction. Because the teletypes can't support images. And so ultimately it's only what the text is, and that text is the name and date of birth. So
And on that sense, Judge, would his fingerprint goes with
That's what and that's why I was, they've got these mobile apices that,
the mobile thing where they could just test them and see if it's his prints or not.
sure, but the majority of warrants, the way they're sent by teletype, again, a thumbprint can't be imaged in a
I
teletype.
got you.
So yes, there is a thumbprint, but there's no way
the
to.
thumbprint should be able to verify who this person is, whether they have the correct date of birth.
But
Mugshots.
that only corresponds to the warrant for the demanding jurisdiction if they have something to match it against. So that's the issue is, yes, it can pull it up on our side, but it's the same way even for our parole violations is they can't check on scene, especially at 1 a.m. That's why we're the second check, is that we're able to verify if there's a thumbprint, mugshot, etc.
You're going to be released here momentarily. I'll have Ricardo tell you how to take the next steps though, okay? All right, good luck, Mr. Martinez. Thank you.
This case raises serious questions. Is justice being served, or is it a not-so-subtle call-out to the officers who tossed Mr. Martinez behind bars just because he had a common name? Either way, Judge Fleischer didn't let this one slide.
It's not in Harris County.
He switches between 50 and 59 in the offense report, Chief.
I know probable cause.
Yes, Judge, and we understand.
And just when you think the string of wrongful arrests might finally be over, here comes another one, and Judge Fleischer looks like he's officially over it.
Good morning, Mr. Lozano. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, Judge. On February 7, 2025, at approximately 10:08 p.m., the officer was dispatched to a major crash on the 200 block of South US 50 freeway in Harris County, Texas. The officer met with other officers at the nearby gas station where they had moved the scene. The wheel witness stated she was rear-ended by the defendant and was able to put the defendant behind the wheel of the vehicle. The officer observed front-end damage to the defendant's vehicle, and the officer made contact with the defendant, the driver, and occupant of the vehicle. The officer observed slurred speech, staggering, and disorientation and confusion. The standard filtered writings were conducted, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The defendant stated he did not drink any alcohol that day, and the defendant was read the DIC and refused to provide a breath specimen. A blood search warrant was signed and executed.
Williams?
The judge, sounds like there's no probable cause because US 50 is not in Harris County, Texas. That's what the road they said it happened on.
Where is it?
It's at US 50. That's not in Harris County.
And the DIMS does say 200 block of South US.
Are you serious? Do I need to look it up? I don't know.
Your Honor, the
I did.
DIMS further says during the scene of the accident, which occurred on 200 block of South US 59 freeway, Harris County, Texas. But counsel is correct that before they said he responded to a major crash call for service on the 200 block of South US 50 freeway. So they put 50, but then later in the DIMS they did put 59.
All right.
So they're just two addresses, so I don't know why that's there. But they did say the accident occurred on US 59.
Well, that would be a different story.
Do you have any other evidence that is pointing to that it's at 59 or is it 50?
So, Your Honor, the only thing we have is that statement from the officer, which states that the accident occurred on 200 block of US 59 in Houston, Texas 77004.
Is that what really happened or was it on 50?
So that's what I can explain is the officer put.
I'm not working on hunches here, man.
And I understand, Your Honor. The officer initially said he responded to a crash call for service, which occurred on US 50, but then later said the accident occurred on 59. So let me see if we
definitively point it is.
I'll check the OR and see if they clarify in the complete OR. And in the OR as well, the officer says, which occurred on 200 block of US 50, Houston, Texas 77004.
So is 50? It's not in Harris County.
He switches between 50 and 59 in the offense report, Chief.
I know probable cause.
Yes, Judge, and we understand.
All right, Joe.
Thank you, Judge.
All right, Mr. Lozano, be careful out there. You know what I mean? Really. Just listen to. He's great. He'll help you out whenever you need. You know. All right, man. Good luck.
Thank you, Judge.
In the end, the judge saw right through the nonsense, and what could have been yet another wrongful conviction turned into a win for justice. As always, thanks for watching. If you enjoyed this wild ride, don't forget to hit that like button and subscribe. Let us know about your favorite moment in the comments below. We'll see you in the next one. The judge saw right through the nonsense, and what could have been yet another wrongful conviction turned into a win for justice. As always, thanks for watching. If you enjoyed this wild ride, don't forget to hit that like button and subscribe. Let us know about your favorite moment in the comments below. We'll see you in the next one.